All right, if you just joined us, he's still on to Enterprise Weekend, reaching you from Enterprise Television. Let's get to our main conversation in a bit. Justice Binta Nyako of the Federal High Court in Abuja has resumed presiding over the treasonable felony case against Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, after briefly recusing herself.
Kanu, who has faced charges related to his separatist activities since 2015, pressured Nyako to withdraw from the case in September 2023, accusing her of bias and disrespecting a Supreme Court ruling regarding his rights.
Following his outburst, Nyako stepped down, but the Chief Judge, John Toso, later directed her to continue.
This was to allow Kanu's lawyer, Aloy Ejimako, to formally submit an application for her recusal, which the judge will evacuate before deciding whether to remain on the case.
And also, Kanu has been in detention since 2021 after being rearrested in Kenya. His trial has experienced numerous delays due to legal maneuvering, with multiple judges recusing themselves.
Nyako has overseen the case longer than any previous judge. Despite Kanu's lack of confidence in the court system, the prolonged delays and judicial changes have further complicated the trial's progress.
Very true. All right, to have this conversation this morning, I have joining us virtually from Lagos, Barrister Evans Ofelihi, barrister at law and public affairs analyst, and Comrade Murphy Abadoni, a public affairs analyst. Good morning to you, gentlemen.
Good morning.
Good morning.
Yeah, thank you so very much. I would love to, thank you so very much. I would love to start with you, Barrister Evans Ofeli. Maybe you might bring us up to speed. When Judge Nyako has reaccepted the offer to continue the trial after recusing herself, what is the importance of this particular move? Are there things that the Nnamdi Kanu lawyers should be scared of at this particular point?
Justice Nyako recused herself after Nnamdi Kanu's outburst in court, saying that they are not sure of getting justice in the matter based on the way Justice Nyako was going about the matter. Now, the genesis of this vista was that there were pending applications that ought to be heard, interlocutory applications. And those interlocutory applications in law, they are supposed to be taken before you go into trial. Now, Justice Ika wanted to go into trial in the mix of those pending applications. And part of the application has to do with the jurisdiction of the court, being that the offenses so alleged were not committed in the country. When that was done, the federal government amended their charge, and there are other two applications pending. So, from the practice of law, what they ought to have done was to hear those interlocutory applications before descending to full trial. So, but the judge wanted to go on trial when the interlocutory applications were pending. That was strange anyway. When he made that statement that he does not, he want the judge to recuse herself, she moved further to recuse herself. But there was no formal application from Nnamdi Kanu to the chief judge. So to that effect, it was just the expressions made in court that the judge took herself and then went straight to recuse herself from the case. But she does not have the final authority on cases assigned to her. Okay, if the chief judge insists that she must continue on the case, she has no choice but to go back to continue that case. The chief judge is the administrative judge of the Federal High Court, and he's the one that can decide so. But the truth is that the dent we're seeing in this whole thing is that the defendant and the defendant counsel seem to have lost hope on the way the judge is handling the case. And then in law, it is not wrong for a defendant or for an applicant or plaintiff defendant or whatsoever, or claimant, to say to the court that they are not satisfied with the way the case is going. And so either the judge should recuse himself or they apply to the CJN to reassign the case to another judge. Okay, so that is how it is done. For Nnamdi Kanu's case, you also know that this case is political. It has political undertones, and the political undertones have not been resolved. The federal government fears the issues are so much in this case that one needs to be very careful as to what should be done. But in my own view, I would have advised that Justice Nyako cancel that case.
Okay.
But the Federal High Court administrative system otherwise. So let her continue.
Thank you, Barrister Evans Ofeli. Murphy Abadani, now I'm coming over to you. Yeah. There are some political undertones with which Barrister Evans talked about. Now, I would like you to throw more light on this, should we call it legal maneuvering that has actually happened for the reason, which is one of the reasons why Nnamdi Kanu's case is taking longer than normal. Now, can you just throw more light on that legal maneuvering that is happening in Nnamdi Kanu's case?
Thank you very much. As a matter of fact, I am one of the persons. In fact, Evans has spoken very lengthy on this particular issue, and in fact, he has spoken my mind on especially most of the areas of the issue. This matter, first of all, has a very strong political base, very strong political undertone, and if you ask me as an individual, I would have advised that Nnamdi Kanu and his legal team, and by extension, the Southeastern governors, I mean the 5 Southeastern governors and the Ohanese leadership, should have taken a step further to embrace political solution, political options, rather than the legal route that they were backed on. Now, we talk about the legal maneuvering. When you are issued with the Federal Republic of Nigeria, an issue bordering on the charges of treason, please underline that treason. It's always very, very difficult to get judgment the way you may expect to have judgment. Now, even when you go to the international community, right, you know, at the end of all this, Nnamdi Kanu himself would have thought that the international community was going to come to his rescue, particularly the UK, where it's alleged to have their citizenship. But after so many years gone by, this after about 9 years gone by, the British government has not taken any good stand on Nnamdi Kanu's issue. In fact, there are neither there on the issue. And that would have gone a long way to give some signal to Nnamdi Kanu and his legal team that they needed to tread very carefully. That is that. Then, again, when you have issues that have a political undertone against the federal economy of your country, Nigeria, even if you claim not to be a Nigerian, sometimes claim to be an Israeli and whatever, but that is for tomorrow. It is very difficult for any judge to give you judgment against the federal republic of Nigeria, especially in an issue that is so technical and delicate like this particular issue. And I must say that enough of this grandstanding by Nnamdi Kanu is not going to lead anywhere. You have done that for about 9 years now, and if the results have not been good enough, it is only natural that you change your tactics. It's only natural that you apologize, and that is where I have to blame maybe it's legal team, but it's another thing to have a legal team. It's another thing also to listen to the advice of your legal team, like what we are doing so far is conduct so far in court, as obviously shown that this person does not listen to his legal team. So you could see his conduct that the way he was shouting down his lawyer, and the way he went further to speak of course, like Evans has mentioned earlier, it is not out of law to ask the judge to recuse him or herself from your case. But there are procedures for that. It's not something you just go to the court and arrogantly and rudely just take to a judge, which was what Nnamdi did.
But Mr. Murphy, yes, yeah, I wanted to ask you. You did mention that when it comes to cases like treason, it's often very difficult to get the right judgment. But let's give you an example. Showore with the revolution now, he was equally charged for the same case. And if you maybe juxtapose his character with that of Nnamdi Kanu, it seems to be insympathical. So why would the Nigerian state, of course, remove totally the charges against Showore, but still the charges against Nnamdi Kanu remains?
Thank you very much. In law, no two cases are the same. You know, they may appear the same before the eyes of the public, but there are facts of these cases that differ from one another. And if you follow the case of Showore, and if you follow the case of Nnamdi Kanu, there are so many differences. The way and manner. I don't want to go into some of those things on air. But if you have followed Nnamdi Kanu and his conduct from the onset, you know that he will actually have a party. It's very obvious that he will have a party. It's not exactly the same case with that of Showore himself. But being that as it may, Nnamdi Kanu, having been on this for 9 years, shows that a guy forgot his lawyer and forgot his treatment. When I mean his treatment under the circumstances, I'm talking about the Ohanese group, the Southeastern political leader. Because whether you like it or not, in my view, the only way out of this issue is to have a political discussion, is to have a political negotiation. That is the easiest, the shortest, and the only way out of this whole problem. And the earlier, the better, and the Kanu embraces this, the better for me and those our brothers and sisters on the surface who believe in so-called struggle.
Okay, thank you, Murphy. Barrister Evans Ofeli, what will be the solution if you are Nnamdi Kanu's legal advisor? What will be the best advice to give him concerning this case? Looking at the way other sources have actually said that they've actually asked Mr. Ejimakor to file the recusal application of the federal government lawyer, Mr. Awomolom. That's his son. So what would be your best advice to Nnamdi Kanu to handle this issue better and to handle this case better? So this 10 years or 9 years long would actually become shorter and he can actually gain his freedom or maybe face or dance the tune to the music.
He need to explore multiple areas of solution in the case. He need to explore multiple areas of solution in the case under reference. Given that the foundation of his case is based on secession, that the Southeast, his agitation is that the Southeast is marginalized, they are being maltreated, and that he wants a situation where they will be allowed to go their own way. Unfortunately, the 1999 Constitution as amended does not have provision for that secession. Okay, that's the foundation. The Constitution does not have a provision for secession. So what do you do then? I've advised before the whole of ACO. I've advised before that what they need to do is to apply the African Charter on Women and People's Rights, which is a domesticated law in our country, which will vote on fundamental rights issues in our courts. And if you look at Section 21, 22, and Section 23, it defines how a country or a group of persons or tribe or ethnicity or whatever that wishes to secede from the country, the steps and the procedures they must undertake is in that law. I know the African Charter on Women and People's Rights is part of the laws of the Federation because it was domesticated almost by 42 countries out of 52 countries in Africa. Now that charter is valid in our law. Why not export it? Because the truth is, from the attempt to use violence to achieve secession started in 1966. Okay, then it moved now. You know, you got into the Biafra War from 1967 to 1970. A full-blown war could not achieve that purpose. So is it the cry of one man or a group of persons that will now achieve the purpose? Now, the reason the international communities were not coming to assist or to is because the foundation for this agitation is violence. It's violent. Now, that violence must be taken away from this agitation. That is the truth. Because people will not stoop down low, leave their country to come assist you in your country to true sovereignty or to pull yourself out of a sovereign state forcefully. You understand? These are civilized economies. They won't do that. What if you explore the legal route and then maybe back it up with some international politics? Sympathies will begin to fall to your side, and that is what is required. And if you think that is pushed to a point, that is pushed forth enough, perhaps you will get a reprieve. You will get some level of consideration at some point in time when you quit this. But if this is just about brash, outlandish violence, it's about shutting down anybody, anyone, and creating violence, making very negative utterances on radio and asking people to go and kill Nigerian soldiers, to go and make that is the old stone age. During the time of conquest, that is when you use force, you use gravitas, and then you want to crush people and take over. Since the Industrial Revolution in 1400 down to date, man have devised negotiation, man have devised laws, man has devised regulations, both international and municipal laws, for which you can fight for your rights to the point where you'll be given whatever you want without violence or bloodshed. Okay? So that is. The other option that borders on the law, of course, the legal team. The other option that borders on the law, of course, the legal team should know what to do. In this case, they need to come formally to the court to ask for this recusal. They need to come formally to the court or by an application letter to the CJ for a reassignment of the case, giving reasons why this should be so. Okay? Because I don't even think Justice Nyako herself is enjoying this whole thing. Because a lot of issues is placed on this case. The judge herself may also be tired of the perturbations and the twists. And because the case also borders on, and then because the case also borders on preservation of states, okay, preservation of statehood and countryhood. So you don't expect it to be just like a regular case.
Yes.
By the wayside that this can pass just within a jiffy. It's a very serious matter.
Yes, I wanted to ask you, Mr. Abaduni actually talked about the desire of the British government's muteness on this particular case. He wondered why the British government kept mute all the while Nnamdi Kanu was making such utterances against the Nigerian state. So why do you think that is so? Maybe you could equally take us through his kind of nationality. Is it by registration? Is it by, we do not know. Put us through. What do you think has made the British government so mute that it couldn't reprimand Nnamdi Kanu that had escalated to what we have today? Yes, that's for you, Esteban Sufeli.
Okay, is it for me?
Yes, please. Yeah.
Okay. Why the British government have kept mute?
Yes, exactly. While the utterances went all through to getting to where we are today.
It's not the responsibility of the British government to come and define for us what our laws should be or what our constitution should be. They know that in the 1999 constitution, secession is not part of it. Okay, they know that. So they're not going to come authority to break our laws to ensure that agitations are. And for those persons, Nnamdi Kanu is of dual citizenship. It's a citizenship by registration.
Okay.
In the UK, it's not a citizen by birth. Because sometimes we talk about citizenship, we talk about it look like. It's like those Lebanese people now like that are in Nigeria who are citizenship by registration. Then maybe there's an issue in Lebanon now, just like the issue that we are having in Lebanon with Israel and the rest of that. For the issue that's going on in the Middle East. They now say, okay, because some of their citizens are here and they are citizens, the Nigerian government should go into Lebanon to go and fight Israel or to go and tell Israel not to have issues with the Hezbollah and all that. And it's a very sick way of reasoning. You understand? It's not the business of the British government to, come do anything because one of their citizens is held in a country where the laws do not permit what he wants or what his group wants. Okay, the British government will either come to his rescue when you have conducted yourself very well, when you are exploring the legal route to the issue under reference. Then they will come with dignity. Okay? But if it's by violence and by force, okay, why didn't they come into Nigeria during the Civil War to rescue those who are their citizens that are of that extraction?
All right.
Thank you.
This sovereignty must not be toyed with.
Okay. Thank you, Barrister Evans Ofeli. Murphy, looking at the current situation now, but checking our time, we just have to call it a wrap. Let's get your parting shot on this particular story.
Can you come again, please?
Yeah. Can we get your parting shot, please? Just maybe in 1 minute, can you just put together your thoughts as we wrap up on this particular story?
Okay, very good. Thank you very much. And the point is this, like I said earlier, first of all, Nnamdi Kanu must also at this juncture define in a very clear terms what he wants to. And because maybe it aims to be just grandstanding and noise making and the rest of it. That's not his aim. Because for some people that is a strategy. But for me, at this point, I will advise himself and his legal team and his political leaders, I'm talking about the leaders on that team, to look for a way to resolve this issue politically, because that, like I said, that is the shortest cut for now. Approach the government in a way. It was the same by the government of former President Muhammadu Buhari. That Buhari spent 8 years in office. Today, Buhari is the former president. It still be the same. President Nnamdi is now the incumbent president. If they do not negotiate politically, if they do not admit that this is our son, but they have heirs, and if your son is a citizen, is the son of the soil, and plead for pardon, I doubt if the legal route is going to lead any positive result. So my conclusion is that they should embrace political negotiation. Thank you.
Thank you.
Thank you so very much, Barrister Evans Ofeli. Maybe you might just conclude with this. Legally, if this continues and, of course, it ends in a deadlock, what do you think would be the best route after now? Please, in 60 seconds, please.
Yeah, what I meant by using the legal route is after his release, that is what you should do. That's what I'm saying. So you should not go violent again after his release. You should go and explore the law, but the law is there. You understand? That is, see, after his release, he's still agitating for secession. He may decide to pull out. They may decide to forget about it. Okay, after all, we're actually better off in the one Nigeria.
Definitely. Yeah.
Because it gives us that number, that strength. And what else do we want if we are able to pull our businesses and resources together and develop faster as one nation? Fine. What I'm saying, I will leave. Mine is that you shouldn't say that using violence as the yardstick for that. Yeah. You must do that according to law if you have a second opportunity to do so after it.
Okay. Very, very true. I'd love to say thank you so very much, Comrade Murphy Abadoni. Thank you so very much for your time. We appreciate you, Barrister Evans Ofeli. Thank you as always for being there for us. We truly do appreciate you.
My pleasure.
Thank you so very
My
much.
pleasure.
All right, so people, that's just about the time we have today on our show. We'd love to say thank you to you for being part of it. We truly do appreciate you. But please do well to visit us when you want to. You can always find us at enterprisetvnews.com, and also you may like, comment, and follow us on all our social media platforms at Enterprise TV7. I am Henry Ikwebike.
And I'm Choma Okohe.
On behalf of the Backroom Boys, thank you for watching. We'll see you next weekend. Bye-bye from us.
Bye.
Yeah.
Enterprise TV, a tradition of truth.